Our next panel will focus on the legal issues arising from generative AI and derivative works, not just in the creative industries, but in other sectors too. How are different sectors and regions approaching the issues of legislation and regulation? And how do we balance the need to protect intellectual property while encouraging innovation? Chairing this next session is Amanda Brock, the CEO of OpenUK. Amanda is an incredible lawyer with more than 25 years of experience. She's chaired the Open Source and IP Advisory Group of the UN Technology Innovation Labs and is listed in Computer Weekly's 50 Most Influential Women in the UK Tech 2023 landscape. Welcome.
Thank you very much, and good afternoon, everybody. Great to be back at the ODI Summit one more time. And this afternoon we have a fantastic panel to focus on AI and some of the legal issues surrounding it. We're joined today by Ed Parsons, who is Google's Geospatial Technologist. We have Vic Khurana, who's a partner specialising in commercial at Bristows law firm. And we have Christiane Wendehorst, who is a professor in civil law at the University of Vienna. So welcome to our panel this afternoon. I don't know if we've got the short or the long straw, to be quite honest. AI, talking about legal issues in AI, everybody's talking about it. Rishi Sunak last week at the summit, King's speech today managed to reference AI safety going forwards. And as we think about this and we think about where the legal positions are going to fall in AI, what we've mostly seen people talk about is the creative industries, the creative sector. And of course, that's just a drop in the ocean. We're really looking at a much bigger picture. And there's all sorts of different areas that AI touches on, including geospatial, Ed. What are your thoughts?
Absolutely. And in some ways, I guess I've been a little bit frustrated over the conversation and the way the conversation has gone, I guess, in the last year as you know, large language models, GPT has become the flavour of the month. Because in many ways, we've been using machine learning for at least 10 years. And we've got massive benefits from applying the technology to solve problems that we just couldn't have done using conventional human methods. We can process volumes of data that we've never been able to do before. We can identify insights in patterns in that data that again are truly new and innovative. One example, we've created a data set of literally every building in Africa, Latin America, the Caribbean, South and Southeast Asia. 1.8 billion buildings we've been able to identify automatically from satellite imagery and make that data openly available to people. That's a massive benefit that comes from the access of machine learning to these really large data sets. And I guess we're probably to blame for not blowing our trumpets more, but it's been great up until this point. My worry is that unintended consequences of putting in place frameworks that are driven by the creative industries will perhaps stop us getting access to these data sets that have been so useful to us.
And I guess that access to data sets is critical because what we're looking at with AI, particularly the generative AI that we're all talking about now, at least since the beginning of this year, and ChatGPT-4 and what was it, February? I think what we're looking at, and I think I've mentioned this to you before, Ed, I always think of it like a mincing machine. So you've got this technical architecture that's like the mince machine with that handle that grinds like the video in another brick in the wall back in the day. And what you've got going into that is your raw steak, and what you have coming out of it is mince, right? And I always think of the data going in like that steak, and it depends on the quality of what you have access to, the quantity of what you have access to, and what comes out the other end if we simplify it to its most basic. And then what comes out, of course, is slightly different. It's been chopped up. You've got that mince, but you can go off and make a burger. You can have filet mignon. It really depends on where you're going to go with it. So, at its simplest, we've got the inbound and the outbound. And of course, that data may not be the same when it's spat back out, and it may not be treated the same from a legal perspective, which we'll get on to in a few minutes. But
I think that's a very good analogy. I think, and this is really important, and it's great that ODI are concentrating on this, because the one thing we actually really have a handle on is the input. Pretty good understanding of the data sets that we're putting in, but we don't understand the mincing machine. And I think it's really important to have that understanding and to really concentrate on you know, the provenance of the data, its metadata, because there's a thing we can really have a handle on when we won't necessarily have complete control or sight on how the mincing machine itself works.
Yeah, and I think that really is important. We're not just looking at data when it comes to that. We get into my area of open source software, something that we've seen really lacking in understanding when we look at the regulatory and legal landscape. There's been an understandable tendency, I think, to very much focus on AI and bring in AI experts. And I think there's a void there around understanding how open source works and all the benefits that we get from that transparency, particularly in countries like the UK that are going to need to access those black boxes and have them opened up if we want to have an innovative sector. So we're thinking about this landscape and the landscape with the creative industries who obviously have one set of rights concerns. I imagine, Vic, that you see quite a lot of that in your practice. Where are you seeing the issues arise?
Yeah, it's really interesting because I mean, I do a lot of work for kind of AI companies, you know, trying to get compliant with GDPR and how to think about some of the IP risks. But some of the kind of more real world issues I see in the commercial sphere are companies, organizations, government bodies looking to leverage and use more recently generative AI tools, although I totally get Ed's point that, you know, machine learning and has many different techniques and has been around for a long time. But they want to get the benefits of these tools now and work out the appropriate use cases for them. But they're trying to work out how concerned they need to be about, you know, the different categories of, you know, perceptions of risks going on around accuracy of some of the outcomes, what happens to some of their confidential information as they start, you know, uploading them to these tools, you know, how much they can rely on, you know, the IP ownership of what comes out, those kinds of things. So I think some of this is going to be dealt with through regulation, and I'm sure we'll come on to talk about the upcoming EU AI Act and maybe the UK government's posture in this area. But kind of right now, in the absence of that being enforced right now, people are looking to understand and do risk assessments around these things. So what I find really interesting, and the more we try and delve into it, is the different sort of technical and architectural solutions and models out there, which actually are starting to ameliorate and address some of these points. So, for example, people thinking, okay, well, maybe I won't be using the public version of ChatGPT where it can use my data for lots of things. Maybe I'll look to license in underlying models and maybe fine tune them and trying to get the right expertise and talent to sort of do that in a way that, you know, complies with the kinds of guardrails as an organization they're sort of setting. So while I think at a more macro level we'll have regulation, legislation, and then the courts weighing in on things like copyrightability and those kinds of IP infringement issues, I think at the moment I see a lot of businesses think, okay, we need to do risk assessments to work out, well, how worried do we really need to be about the use of data and confidentiality? Can we design use cases that mean we don't have to worry so much about whether we own the IP from it? You know, maybe we won't develop our brand logo using ChatGPT right now, but maybe we'll use it in our people's workflow in a way that's sort of consistent with saying, look, from a safe and ethical and legally compliant kind of view, these section of use cases are kind of fine for us and we'll feel our way through. So there's a lot of experimentation out there, but I do see companies and organizations of all sizes being quite sensible and quite attuned to some of the risks and trying to deal with them in quite a practical way.
So what we're seeing is that the creative industries have really had the focus, but actually every industry, because AI is going to impact every industry. So whether it's geospatial, whether it's retail, whatever the marketplace is, we're going to have to think about how AI is going to fit into that. It's one of the reasons when it comes to legislation that I tend to be focused on principles, but we'll come back to that in just a moment. You mentioned in there risk, and I think risk is absolutely at the heart of this. It is the fundamental question, and it is what is our risk tolerance and what is the actual risk? And what we were really seeing coming out of the AI Summit, where they were starting to talk about science fiction becoming science reality, is that the risk needs to be better understood, and we're not probably quite there yet in regulating. Christiane, I know that you're sitting today in Vienna and joining us from continental Europe. The views that I've seen and the approach to regulation, which we'll come on to in a moment, have been quite different from there. I wonder where you find yourself looking at the different sectors and industries.
Yes, thank you so much for inviting me. And I think it is absolutely right to say that the creative sector is just the tip of the iceberg. It's really going to affect almost all sectors, all industries. So this is why the EU has been focusing on a more cross-sectorial, a more horizontal approach so far. And we've seen that in many different areas. And by and large, you can say that EU law and regulation that is either already enforced or in the pipeline focuses on one out of three different dimensions. So, and it very much depends on what is your primary concern. So we see legislation out there where the primary concern is data protection rights, privacy rights, or business secrets. And this is, of course, something like the GDPR, the Privacy Directive. And mostly these pieces of legislation take an autonomy-based approach. For example, consent is at the heart of the GDPR, right? Then we see the concern about intellectual property, trade secrets, but to an increasing extent also data rights. And there we have more of a focus on property. We have more a solidarity-based approach. And as you were mentioning, generative AI, for example, the DSM directive with its its rules on TDM, on text and data mining, has been very influential and important in Europe. And then, and this links back to what you said about the risk, we have the types of regulation that focus more on the harms that could result from AI use. And these pieces of legislation, and notably the forthcoming AI Act, they take a more risk-based approach. And arguably, this risk-based approach, combined with a solidarity-based approach, is the future. And we need to look at existing pieces of legislation, whether they are in line with this risk-based and solidarity-based approach. And this is where I see the future of EU legislation in the field. But yes, EU is a region where we're heavily legislating, and sometimes this is contrasted with other regions in the world. I know that there are different approaches, but EU has taken this approach, and when I speak with colleagues in the US, some of them congratulate and say we wish we were on the same page, but needless to say, not everyone does. So.
That is interesting, because I'm one of the not everyone's, to be quite honest. I think that if you legislate in that granularity, and you legislate in that granularity at such an early stage, it is very difficult to allow the legislation to be flexible. And I think that probably comes from my background, where 30 years ago I was working on the policy and the legislation around the internet. And I think we very much have to learn from that time and not make the same mistakes twice. And I believe that the mistake we made was to create very rigid legislation that wasn't flexible, that wasn't agile, and tried to deal with every issue that we knew. But of course, we couldn't have imagined social media at that point in time. So we didn't make legislation that was fit for purpose today. And I think what we really need to see is how the legislation is going to play out. So how that legislation is going to be able to adapt over time as we understand better the real risks of AI. One of the things we saw from Sunak last week was he was very much talking, and the Bletchley Declaration, very much talking about 28 countries joining up and the need for this global legislation, cross-border, that if we do it country by country or region by region, it's really not going to work. Now, what we see is all these different kinds of legislation coming into place. But what does that mean? Where is that going to take us? Is it actually going to stifle innovation? Vic, I'm going to come back to you first on that. Do you see this disparity in legislation with some countries, some jurisdictions like the EU, ploughing ahead with something very granular, while the UK is saying we're going to wait until we understand better?
Yeah, no, it's a really interesting point. And I think, last week's summit, if you think about the subject matter of that summit, like in my mind, I equate that more to something much more macro, societal type risks. And look, you can say they're science fiction. It's not an area I massively concentrate on. But, they're more at the level of something
Great.
like,
Thank you.
not nuclear non-proliferation treaties in terms of the kind of existential subject matter. And on that level, I totally get, like, you need a more multilateral, maybe global approach to that, because, if you don't, then, rogue states or any group of states could develop something in that kind of way. I think when I think about what the EU AI Act is trying to achieve, and I think about the UK direction of travel, some of the conversations in the States, I wonder if it's always going to be a problem to do it region by region. Because if you think about it, every region or country could look at it from the perspective of trying to protect its citizens in a similar way that we do data protection. And you could say that's a bit of a patchwork. And you could say, well, actually, if you think about the nature of technology and the scale it needs to achieve in the design stage, people want to design for one high watermark level of compliance because that's the nature of cloud and scalable technology. So, and then we know about the Brussels effect and the potential for that to set the bar around the world anyway. So I think while there are different regions necessarily doing their own thing, I don't know really if that's going to be a huge problem at this point. If you think about, well, lots of these things are designed to protect individuals and citizens in certain countries. So, for example, the AI Act, it's got very few prohibited types of AI, and they're the kind of ones that we maybe might all agree that's fine. That probably shouldn't be developed.
No, Vic, I'm just going to pause you there. I'm going to pause you there, and I just want to go back to what you're saying. So you're saying that you think the EU regulation is not going to be difficult, and I was recently with Jimmy Wales, and he was talking about exactly that. And his estimate was there's like 8 companies in the world that would be able to comply with the degree of legislation that was being put in place. And if we're then going to see different levels across different borders, that's going to be a huge burden on the small innovators. That's going to be an enormous barrier for disruption. Vic, did you want to jump in with anything on that? I could see you chomping at the bit there. No, sorry, Vic. Ed. Sorry.
Ed. I thought Ed might want to.
Yeah, I'm looking seriously at Ed and calling him Vic.
I very much agree with your point, Amanda. I think, in many ways, if you look from a technical point of view, the barrier to entry to play in this space, to start to build foundation models, to build frontier models, is already really, really high from a technical point of view. The amount of compute resource you need is enormous. We put in place, regulatory problems that only large organizations with large teams of in-house counsel can deal with, then I think that's problematic. And I think what we saw last week in Bletchley Park is, and what much of the discussion, I think, has been at that meta level. In many ways, the policymakers saying, look, perhaps, we missed social media. We should have regulated that earlier on, and we're living with the consequences of that. Yeah. We don't want to make the same mistake. But actually, sometimes you do need to hold back a little bit and see how the world develops. I'm very much of the opinion that we have lots of regulators for all of the things that are really dangerous that we do in our lives, whether we're flying airplanes, being operated on by medical professionals. Those are very regulated industries. You apply a little bit of artificial intelligence to those, they remain regulated industries, but now AI is playing a role. And I think that would be the approach. In some ways, we just need to maybe cool down a bit. Just give ourselves 6 months, and then let's see where we actually are then.
And Ed, I think there's 2 things there that you and I are probably violently agreeing on. And the first of those is the impact of the regulation on small businesses and on innovation, that will, if it is going to be difficult to comply with, it will stifle it. I think there's almost a continuum from that, which is that if it's only going to be a handful of companies that can comply with it, you're going to end up with lock-in or lock-out across the industry. And AI, like any other tech tool, is a tech tool. And I think the second thing you and I are violently agreeing on is that principles-based approach to legislation, where the sectors are already regulated, the behaviour is regulated, they have to then look at how they use AI as a tool. I would say there's probably some level of do no harm type code of conduct may be required on top of that, in my opinion. And I think that's where Sunak was going last week. But one of the key areas there for the UK is opening up AI and understanding what's in that black box. And it's something Oliver Dowden was enthusing about at the end of the Bletchley Summit. We saw Lord Camrose, the AI minister, saying the UK doesn't have a policy on it. at this stage, and we've had very mixed responses from other politicians. Different countries, it seemed to me like the Commission were very anti-opening things up. They have got some provisions in the AI Act that allow for it, but they're quite restricted. So I wonder, just as we wrap up this panel session over the last few moments, if we could just focus on that. You know, we're here with the Open Data Institute today. Let's think about what the open aspect of this regulation is going to be, because I don't think anybody is actually regulated for it at this stage. And I wonder, Christiane, if you have any opinions on that from an EU perspective.
Oh, sure. And maybe just to come back to what we were discussing just now, I think it's really crucial if you regulate at that pace and at that moment that you get the regulation right and that you don't stifle innovation. And part of what is a problem is often, as you said, that it's just the few big companies that can comply. But the answer to that, I think, is on the one hand, risk-based regulation, as I said. There are some pieces of regulation that were passed in recent years, such as the GDPR, that are not sufficiently risk-based. I think we need to be strictly risk-based and only regulate as much as is really necessary to protect people from harm. And then I think asymmetric regulation is a good reply to that. For example, the Digital Services Act is different with regard to depending on how big the company is. Now, coming back to your question about openness, it's a crucial thing. And now, as we're seeing the trilogue negotiations on the AI Act, the question what to do about...
Christiane, I'm sorry, but we've got less... Christiane, we have less than 5 minutes to go, and I want to get through the other two speakers too. So I appreciate you want to make the point, but can we just wrap it up quickly, please?
Yes, I think the open aspect of how to deal with open source software in the area of foundation models is a crucial point in these last trilogue negotiations on the Artificial Intelligence Act. And I do trust that a lot of care will be given to that, and that I hope we will get it right.
Great. Now I'm going to move along to Vic here. Vic, we're seeing a slightly different approach in the UK. I don't know if you're dealing with other markets. Where do you think we're going to land on this open point?
Yeah, I mean, I think in the UK, I think, you know, as you sort of see the direction of travel, it is a little bit more principles based, a little bit more empowering in a bit the way Ed said, like existing regulators to be thinking about the risks that exist in their own sectors in the same way as they do at the moment. So I think from that perspective, that's going to be, that's going to be where we land, I think. And then we're going to have individual task forces where maybe our regulators can be a bit more nimble and work together to try and solve specific issues and challenges. At the same time, I think at some point we're going to need some more concrete detail there, because our clients and businesses, organizations who aren't always technology companies, who often don't have, they may not be small entities, but they don't have big compliance functions. They don't know how to get to market with new technology. They're going to need some more concrete guardrails as well.
That makes a
lot of sense. But the direction of travel is clear.
And we get back to the guardrails that we've heard talked about in the US. And we're talking about whether the EU there would be a leader, but obviously the US was putting a clear stake in the ground last week along with the UK to be the leader. But it was interesting to see China welcomed as well. Ed, do you want to give us a last thought on that just before I wrap up the session?
Yeah, for me, I think the openness point is very much tied to literacy. I think openness will, in many ways, make this technology easier for many people to understand, which is not the case at the moment. It's very opaque. So, we need to create broader data literacy in society, openness around these services, systems, how they work, because at a fundamental level, it's not that complicated. It is fundamentally statistics, but lots of people don't understand statistics. So I think openness and literacy are very tied together to kind of solve the societal understanding of this technology that will be, hugely impactful.
Thanks, Ed.
But I always will jump on the open side of any debate in terms of technology.
Thanks, Ed. I really appreciate the contributions from all three of you this afternoon as we've sort of debated their way through these issues. I also would normally jump in on the side of openness, but I think it's important as we start to look at risk in AI for us just to be able to acknowledge that there may be some different factors at play. And I think there's a maturity that we're seeing in the open communities as they evolve, are growing up where whilst we want to get that openness, which is clearly beneficial to the UK and other markets, particularly those outside of the US, where we need access to skills and we need access to the innovation that will only come through that openness, I think there's also an understanding that we have to get a better risk assessment to know what those guardrails, if any, are needed in the whole AI space as we look at opening it up. So thank you all for joining me this afternoon, and I look forward to discussing this more with you. I'm sure there'll be lots more to be said on this next year. I don't think it's a topic that's going away anytime soon. Thank you.